Any mention?
There's a judgment. Judgment is the first pronounced judgment. After that mention.
What judgment? Item number on WPCP 14 of 995.
This writ petition is allowed. The impugned judgment is set aside. Respondent is directed to regularize the petitioner's service immediately with notional effect till the date of judgment and thereafter with actual effect. Necessary order in this regard shall be passed within a period of 4 weeks from today.
Illegally completed by the day from making substantial. The advertisement. BSK would not. So since the substantial question is formulated and met this stage of single, so I intend to rush it. The gap. Instead of detection. All right. Item 2, WPCP 49 of 925.
I am for the respondent minor. In this case, certain documents have not been annexed with the WPC, so I'd like to find my state in a position annexing all those.
Okay. You are the sole respondent. Sole respondent. Okay. But censor and counsel for the petition. Stuff. Learned censor. And this appearance on behalf of the sole respondent and praise for how much time you want to file? It's 3 weeks time to file counter affidavits. Stop. Drafter, so and so, 1 week. January. It will come up in January.
Item number 3, WPCP 15 of 925.
Item number 3, Your Lordship, I am appearing on for the respondent on behalf of my learned senior, Your Lordship. He has gone to his ancestral house for due to some urgent reasons. So I am praying before Your Lordship adjournment and fix the matter in the next circuit bench any day except the 4th December, Your Lordship.
Except the
4th December. Fix the matter any day except 4th December.
on request made by the learned counsel for the respondent, list the matter in the next circuit bench.
Much obliged, Your Lordship.
Item number 4, WPCP 24 of 925.
I have a question.
Yes.
Before I take your lordship to the judgment which is impugned in this case, I would like to take your lordship to the 434 documents, page 6. I was appointed as a head constable mechanic,
Page
60.
60.
This is the order dated 15th of July 1999. As a result of the recruitment held in fire service headquarters report here on 13/4/99, Mr. N. Amadu, of resident of Sadipur, who has registered his name in the employment exchange, is appointed as head constable mechanic. Next page 61, Next page is order number 2568, dated 22nd November 2004. On the recommendation of the Departmental Promotion Committee held on 22nd November 2004, Head Constable N. Madhu is promoted to the rank of Assistant Sub Inspector Fire Service Workshop. I am happy on this board. I am promoted to the rank of Assistant Sub Inspector Fire Service Workshop. What is my? No. Page number 76. The next promotion, on the recommendation of the selection committee met on 99 September 2014, N. Madhu, Assistant Sub Inspector Mechanic of A&M
Page.
761. Bigger number 76. Both are round. One is higher number 76. The next year 810.
What is the date of the letter? Date of the letter, this order,
19 September 2014.
19th.
19. Here I am promoted to the rank of Assistant Sub Inspector, is promoted to the rank of Sub Inspector Fire Service Workshop. Fire Service Workshop.
Oh.
Page number 85. My presentation was disposed of 85. This is very important. Page 85. This is the memo dated 20th October 2008. Sub Inspector Workshop N. Madhu is informed that there is no separate post of Inspector Fire Service Workshop. There is no separate post for this of Inspector of Fire Service Workshop. Hence, he is not eligible for promotion to the existing post of the Inspector stores provision that works. This memorandum itself is contradictory. At one hand, they say that he is not eligible. At the same time, they say there is no separate post. Now, there is a separate post. Separate post was created for the Inspector Fire Service Workshop. It appears from page 78. Page 78, second paragraph. This is the minutes of the DTC, where it has been mentioned in the second paragraph. One post of the Inspector Fire Service Workshop and stores and provisions has been transferred from the strength of A&N Fire Service to Police Motor Transport under the Police Department Port Blair, White A&N decision number such and such, in terms of the proposal moved by the Andaman Nicobar Commission. What is that?
Read it again.
One post of Inspector Fire Service Workshop and stores and provisions has been transferred from the strength of A&N Fire Service of Police Motor to A&N Fire Service to Police Motor Transport under the Police Department Port Blair by A&N and which is in order number 3571 dated 26 September 2011 in terms of the proposal moved by Andaman Nicobar Administration on 19 September 2000. So the statement made by them in the memorandum is absolutely incorrect that there is no separate post of Inspector of Fire Service Club and police. The same post has been transferred there. It appears from the page 80. 80. Honorable Lieutenant, got it, well? 80. This is the order number 3843, dated 7th December 2015. Honorable Lieutenant Governor, Andaman Nicobar Islands has been pleased to revert one post of inspector from the Motor Transport AN Fire Service, which was transferred from the ANN Fire Service to Police Motor Transport by order number 26 September 2011 to sort out the pending. So the post was created. And when the post was created in 2001. 2001.
Hmm?
Proposal was submitted. This proposal is at page 62. Page 62. 60. Bottom part, my lords. From the bottom third line, all the posts mentioned above are.
You have a type copy of this order, of this communication letter.
Which one?
You have a type copy of page 62.
I'll see.
Yours is legible.
I'll get.
It's
Only
not,
last line.
last line is totally not legible.
I'll please.
Get a copy.
Right.
Tomorrow? At so and so for the petitioner, as well as so and so for the respondents. Place the matter. Tomorrow's date. Tomorrow's what? 26. Get a type copy of all the.
Yes, sir. Only this one. I will put a line on this only where the post has been made.
Then you do one thing. Learned, cancel the order. Learned counsel for the petitioner.
Anything else?
Appellant is directed to file a type copy of the communication dated so and so within bracket page 62. Huh? You get the date from the file.
My lord, I beg to appear on behalf of the respondent number 7 in item 5.
I'm there for the petitioner. The London Tribunal, by order impugned, literally have decided the main issue. As an idle formality, the original application has been kept pending. But let me enlighten the facts. So what has happened? What prompted my client to approach the London Tribunal? But the post in question is the post of labor inspector. Lord, exams were held. At the first instance, lists were published. The present writ petitioner stood first on merit. For some administrative reason, that examination was cancelled. This action of the authority was challenged straight away before this court. Without going to tribunal, I approached this court by filing a writ. I paid for some interim protection. No interim protection was granted. Rather, the writ court directed the authority to go with the second time examination. Second time examination was done, Lordship. In the host of rules, again, the statements were published. These aspects were challenged before the tribunal. So far as first it is concerned, ultimately I withdrew it. Because since Lordship, based on the writ court's order, second examination was directed to be held, it was held, I withdrew the petition. Second time when the publication was made, I approached before the learned tribunal. Initially, learned tribunal granted interim protection, directing the selection process to be kept in abeyance. And at the instance of authorities, the interim order was modified. final order of modification was signed, directing the authorities to conduct the exam and to give appointment. The order imposed requirement should the appointment was directed to be held. Everything was taken care of, everything was considered by the child. As I've said, should, but as an idle formality, but the matter is kept pending. The only question which I have raised before the learned tribunal, which I would be arguing here also, my lord, that the examination was supposed to be held for 100 marks. Unilaterally, authorities have changed the will of the game. When the change, they have calculated marks not based on 100, based on 93. The reason assigned by the authorities was that we assume that some questions which we are putting were incorrect. So they have, as I said, assessed the mark based on 93. Because when this action was challenged for the second time, as I've said just now, as an interim measure, interim protection was granted. I'll just take one of that. And I'll take one of first of all, this so assigned. Well, I would see page 269. 269 in order of this court. This is pertaining to the first petition which I withdrew.
There's a second volume.
Page 269, my lord would find, as I've started my argument with these facts, that the first selection process which was cancelled for administrative reason was assailed questions in this writ petition which I finally withdrew. But second time, page 276 was published. Page 276, my lord, can it turn to page 276 of my original writ petition? My lord would find statement of marks. My lord would see the last tabulation. Marks obtained at the top extreme right out of 93. And I'll show the vacancy notice. It relates to 100 marks. But this is something like if during an election there is something wrong, the entire election is to be cancelled. It's not that based on the counting, the results will be published. No. There are judgments of Supreme Court. The entire election has to be cancelled. Based on this 93, how they have come to this conclusion, how they have calculated 7 marks to be a wrong or incorrect marks, it's a really should unknown. Then the approach to learner tribunal kindly comes to page 277. This application is pending. This is the first order which I could obtain from the learner tribunal dated 8th of July 2024. Page 276 has been challenged. Lord, I'm just placing the order of the learner tribunal. My lord, kindly see last but third paragraph. In the meantime, the selection process in this examination will be kept in abeyance. So entire thing was given a standstill. Then, my lord, authorities approached the tribunal seeking modification of this order. And the last modification, I'll just show that also, my lord. My lord, page 305. Page 305. I'm just placing page 305, my lord. This is a modification order, page 305. And the order is at page 314, 314, impugned order dated 16th of July 2024. I'm just placing page 314, the impugned order. Now, learned counsel for the official respondent and learned counsel for the private respondents are present. My lord would find at the top, against the name of the applicant is recorded. Now, kindly take note of it. It is noted that no so on behalf of the applicant. However, learned proxy counsel, Mr. C. Manu, appears on behalf of the applicant and pays for one accommodation defect. The learned counsel for the official respondents and the private respondents submits that initially wide order dated 8th of July 2024, interim order in favor of the applicant was granted by this tribunal. The said order was further modified by this tribunal with order dated 2011-2024 with following modification. The order has been reproduced below. Page 315. Learned counsel for the official respondent and the private respondent further submits that the order dated 21 subsequently challenged by the applicant by way of WPC number 47 of 2024, which was disposed of by the Honorable High Court at Calcutta, Circuit Bench at Blair, video order number 2024, the interlinear direction. The order of this court is recorded. Learned counsel for the official respondents and the private respondents submits that therefore the modified whereby the interim order dated 8/7/2024 was vacated stands correct. Now the learned counsel for the official respondent submits that the selection process has already been completed. Therefore, they may be allowed to publish the results and also be allowed to offer appointments subject to outcome of this OA. In view of the above, we modify the order 21/11/2024 by granting leave to respondents to publish the results and to give appointment. However, it is made clear that such appointment would abide by outcome of this OA. Let this matter be next circuit bench sitting at Pogder under the heading specially fixed matter for hearing. This is the order which the learned tribunal has passed. But my first point of argument is when the order was filed, one of my juniors, Mr. Manu, he was given instruction to make matter on merits because the matter traveled up to this court. We had the when the matter was ready, everything was on record. The learned tribunal, in one hand, recorded the presence of my advocate, in one hand, and it says that none appears of the applicant. So, without hearing us, first of all, the order could not have been passed. Second, Lord, as I've argued just now, that the entire modus operandi conducting the exam, because the exams was for 100 marks. I'll show the vacancy notice. How could they can change the game of rule? If that were the case, the interview granted at the first instance could not have been modified. Even if it was modified, because when last my colleague was there, he was even not allowed to participation. Rather than records that nobody appears, he was given status of proxy lawyer. And it records that no one appears for the applicant. So my first ground of attack so far is consultation. Without hearing the applicant, this order could not have been passed. The order has to go, Lord. And on many, I'll show the vacancy notice. I'll show the vacancy notice, Lord. It's for 100 marks. But the petitioner is an advocate by profession. And Lord, you see page 70. Vacancy notice dated 6th May 2026 for the subject post, labor inspector. Lord, kindly see page 75. The total marks is 100. Page 75, serial number 13. syllabus for executor, no sign at the top, labor law 80, and then then 76, the entire exams has to be done by way of a written examination. It's 76 and list of eligible candidate of the examination. I show the first list which was published, which was cancelled also. I'll show that also now. Just 1 second, I'm giving you. Well, kindly turn to page. Just no, page 118. It was a notice given and find my client's name at serial number 4. My client is aspirant, Santoshi Devi. And this result was, and rather the entire selection process was cancelled at page 1. You kindly see page 1 to 2. At where I have just marked at page 1. It is hereby informed all concerned that the examination conducted Saturday at post of labor inspector stands cancelled due to administrative reason. Then re-examination test will be conducted on 10/11/2023. It's a change of it has to be first selection process and results of 2085. Now, kindly comes to see clients registration side. She secured first on merit. Side. Page 85,
Serial number?
5. It's registration roll and 6375. And now I can compare this with page 1. Name is not 85. Time same registration 505. She stood first. 63.75 she secured out of 100. It was a written exam. Then the entire process was cancelled at page 120. As I said, this was challenged before this court at page 126. I stayed away from this court because at that point, it's not there. And page 126. So order came to me, she was granted, rather considering same. Published by further observed that the application of procedure examination which will be of such examination dispersal of the incident petition. This is time which his lordship under justice allowed to it. That are order shown. Then for the second time, again, in some exams were done. Computer grade test, which is unlearned. This is vacancy notice. Then I challenged the inspection before the tribunal. Initially, it was granted. Second time, it was denied. I went to this court. This court said since it's in fan the tribunal. I can done the tribunal. Then we passed. So my first many counts were firstly, I have not been heard. And the tribunal passed. Second, the action of the authority to change 100 marks to 90, that's unknown, Lord. That's really unknown. We can judgment. What is mentioned that has to be followed. It's purely a change of game. As I've given there is something as regards the change. It's not that there's only passing results, something like that. So I pray to time deciding everything. Then it's an idle formality. The pendency of it's idle formality. Everything is decided. So I pray this application has to be the order has to be set aside and the selection so conducted has to be scrapped. They have to strictly follow the vacancy notice. 100 marks exams. That's all, Murad. It's my humble prayer, Murad. That's all.
You were saying something about a computer test?
Yes, CBT. I'll just show that. I'll just show that. Now, kindly turns to.
Let us see the vacancy notice.
Yes. Now, kindly turns to the vacancy notice at page 76, 75 and 76 for the subject post. 75 to indicate the marks. Evaluation has to be done based on 75. See, 80 and 20 at the evaluation. It's 80 marks for paper. It's bottom. Assessment has to be done on day. Next page 76. Kindly see Lord. 76. Serial list of eligible scan on portal for inviting games objection. So everything is to be done, from business. When we have recall the selection process and challenge for the record, I think cost of invitation also. And so just reads few lines. It is hereby
My lord, I am unable to hear my learned friend's submission, my lord.
kindly bear, sir. Kindly bear me, sir. Kindly bear me. Kindly bear me.
Yes, now I can hear. Now I can hear.
Yes, sir. It is hereby I consider that the written examination conducted on Saturday, confident man and respect of six so stands cancelled state come stress. Posted to visit the website and card. So I'm asking myself, this can't be done. Notice without any optionality, specifies that it is for humans and that house need to sample out. This I have question before the pending original application. So I want to say the lordship orders have shown orders modified in standard. And then there is nothing in the original application decided, but an ID is kept pending. So I pray lordship the entire method of conducting exam has to be scrapped. They have to conduct the exam strict in terms of vacancy notice and some marks. That's my point of argument, lordship.
Yes.
That's all. I'm grateful, my lord.
Lord. Lord,
You are appealing for?
for the official respondents, Lord.
Oh.
Is, 2, 3, 4, 5, Lord.
2, 3, 4, 5. Oh, 6.
There are 2 private respondents,
There are 3 private.
3 private respondents.
All are present. 6, 7,
My
8.
lord, I am for the respondent number 7, Piyush Sharma, Piyush Aria.
And 6 and 8.
But they are, my lord, not tapped.
They are appearing on the last day. They are appearing.
They are present online. Seven is this.
Lord, I am 7, my lord. It's wrongly, my lord, written as respondent number 6, my lord. But I am 7.
Then how about 6 and 8?
Respondent in person during the last circuit, his presence has been duly recorded.
No. Then when the 6 and 8 are not present, there's no.
But the times preceding orders passed here, they were duly represented.
No, they were represented, but today they are not represented.
They are not there, my lord, yes.
That is
This
what-
the matter is for the last 1 week, my lord.
My lord, in the last circuit, my lord, only the presence of respondent number 7 was noted, my lord. Why your lordship's order dated 17th November 2025, my lord.
Respondent number 7 and 8 are the persons who have been appointed in terms of the order passed by the tribunal.
How about 6?
But 6 is not been selected. She is not, but 8 is to be, because if any of the order passed against it, he should be.
8 has
prejudiced. 8 has to be there.
Then we will have to.
Let a fresh notice be issued, my lord, indicating the date, because now my brother is saying he has not got opportunity before tribunal, then they will come and say they will not get opportunity before this.
But the fact remains, my lordship, they have been served with the notice, they have a knowledge of the pendency of the proceeding. If they are abstaining from the appearing, then.
Same thing happened in the tribunal also, my lord.
So direct I can serve the notice. But till such time, the order has to be stayed from his operation, lordship.
My lord, the tribunal is
This has to be.
looking, it is.
My lord, so far as respondent number 7 is concerned, my lord, may I, my lord, make some submission, my lord. My lord, kindly comes to the last impugned order of this, my lord, tribunal, my lord. That is at, my lord, page. It starts at, my lord, page 314, my lord. My lord, may I take your lordships to the, my lord, the operating portion. That is, my lord, the last paragraph, last second paragraph, my lord. In view of above, my lords, I got that page 315. My lord, in view of above, we modify the order dated 21/11/2024 by grantee linked to the respondent to publish the result and give appointments. However, it is made clear that such appointment would abide by the outcome of this way. So, my lord, first of all, my lord, I make this submission. So far as the way is concerned, that is, my lord, still pending. There is, my lord, no final adjudication as to the issue which has been, my lord, raised by the
Have you been,
petition.
you are appointed.
Yes, yes, my lord. Offers have been issued.
In terms of the modification.
I have given the, my lord, appointment letter, but my, so far as, my lord, my appointment letter is concerned, that has been, my lord, made subject to the outcome of way. Now, my
Yes.
lord, what I am apprehending is that now today, if I accept the appointment, and tomorrow, my lord, ultimately, if the OA is decided otherwise, then, my lord, my appointment goes. In the meantime, my lord, I lose opportunity to get, my lord, another job, or if I am appointed in another job, would not be able to, my lord, take the, my lord, appointment. So, my lord, if I, my lord, may propose, subject to correction by your lordship, my lord, let me, my lord, be added as a party in the way. I have not been added as a party in the way. I was not made a party in the way. And, my lord, so far as this appointment or appointment order is concerned, my lord, let this be stayed, my lord, till the final decision of the way.
Lord, that cannot be, my lord.
Even the private respondent, right, one other supporting her.
Let me
My lord,
clarify.
because otherwise, my lord, kindly appreciate what happens.
One thing, let us have the respondent number 8
8.
before us,
Yes,
before passing any orders.
yes, my lord.
You serve notice,
My lord.
then we can have it listed one of these days or in the next bench.
No, we are almost at the fag end. We are almost at the fag end. Because today, Tuesday, that's a whole difficulty because Malad was seeing the affidavit was convinced, notice is served to him. He appeared so.
Okay, let us, take, but you serve it.
I'll do it. I'll do it, my lordship.
Okay.
I'll do it.
Learned counsel for the petitioner, for the applicant, a petitioner shall take first steps for serving notice under respond number 8 and draft file affidavit of service.
No.
Next bench
No,
then,
my lordship, until such time the interim order needs to be stayed.
Not, my lord. You have complied, but it will be prejudicing to the interest of the 7 and 8 because already a person.
Seven is saying that interim order has to be passed.
He cannot do that, my lord. It is, we are required, my lord, because the labor inspector is shortage of labor inspector.
No, instead of next circuit, let it come day after. Let me, because the respondent number 8 resides within the vicinity of Port Blair. Let me make an attempt. If time permits, I'll bother my lord. Otherwise,
Yes, my lord, kindly, my lord, have it, my lord, day after tomorrow, my lord, kindly.
day after.
Friday.
Yes, well.
Friday, my lord. I'm so grateful, my lord.
Grateful, my lord. I'm extremely obliged.
Item number 6, negative 46 of 125. Followed this matter of senior address for the recorded law. Seeking for short pass over.
Short Passover.
Item number 7, 2050 and of 125.
Pursuant to the
Your
lead.
Lordship, I am appearing in this matter for the respondent number 1, who is also the petitioner in the order impugned, Your Lordship. Your Lordship may kindly seize the order, my lord.
Take the
The
page.
order has nothing adverse, my lords.
Let me take the
The
page.
order only has remanded the dispute of the construction being on forest land to the rightful authorities.
Let us hear the appellant first.
My lord.
Now, page 49 of the memo. The things were suppressed before the writ court as regards service of notice. First of all, I'm on that. But despite service, none appears on behalf of the respondent number 6 because I have been arrayed as respondent number 6 in the writ petition. I'll come to the notice part. The petitioner is erstwhile Pradhan of Nilambur village and submits that an unauthorized construction is going on over forest land. Reliance has been placed on the land records. The nature of use of land has been classified as jungle. He alleges that the respondent number 6 encroached a jungle and started construction. The construction is going on by felling trees and without any legal right. Mr. Rakesh Kumar learned advocate for the Forest Department submits that the Forest Department filed a notice dated November 3, 2025, issued to respond number 6, inter alia stating that the forest land should be vacated and all ongoing construction should be discontinued with immediate effect. Appropriate proceeding will be initiated by the appropriate government under these rules. Considering the facts that the Divisional Forest Officer Baratang Division has already issued a notice, this court is of the view that the writ petition should be disposed of, directing the subdivision officer to take appropriate steps in this regard as permitted by law. Needless to mention that in the proceeding which have been initiated, the final decision will be taken by the forest authorities upon hearing both the parties and upon causing any inspection as to the nature of construction. The revenue authority shall also render assistance in this regard. Unauthorized construction cannot be allowed to be continued and should not be allowed to stand on the forest land. Necessary orders shall be passed and communicated to the parties. The entire exercise shall be completed within a period of 3 months from the date of communication of this order. The respond number 6 shall be heard and allowed to file documents and statement in support of our construction before the authority. But the first and foremost thing is, my lordship, the writ court records that notice has been served. Let me take my lords to that first. You have annexed the writ petition and the affidavit of service. I'll show that. That kindly turns to page my lord 42. Page 42. The affidavit service filed by the writ petition before the writ court. Lord would see serial number 4, page 42. I have served covering letter dated 31/10/2025 along with the scanned copy of writ petition along with all legible annexures by registered report to the respond number 6 in the instant matter. The writ petitioner on affidavit falsely says he served. He should have said he should have dispatched. This was not served to my client. I'll show with their track report. But kindly turns to the track report, page 47. Page 46 is the postal slip. Page 47, Lord would find, Lord knows if the item is given to me, it must contain, it was delivered consignee. Lord would find no one records that it was given to my client as respond number 6. So they simply dispatched the petitioner. Impression was created before the writ court and the service has been effected. So the writ court passed the first line, despite service, respond number 6 did not appear. That's first part. Second one, merit. Lord, I am residing there. It's not a forest land. Why I am saying so? Lord, I have electricity connection in my deceased husband name. Lord, in this island, in view of the larger bench judgment, Abhimanyu Majumdar case pertaining to the electricity, it clearly delineates electricity department can grant electricity connection only in a revenue land, not in forest land. Whereas electricity connection is in the name of my husband, deceased husband. Meaning thereby, the land in question is not a forest land. So thirdly, not the writ petition, what would see the order impugned? Everything has been decided. Lord, there is a judgment of Supreme Court in the Andhra Pradesh State Road Transport case. I'll place it when a writ court is decided, disposed of, some direction can be given. A simpliciter direction, consider representation without recording entitlement, perfect. Second direction is the writ court would record the entitlement order and would direct the authority decide now in the light of entitlement. The impugned order falls in the second category. Everything is decided by the writ court based on the submission made by the writ court, based on judgment. And simpliciter authority has now been asked to take a decision. When everything has been decided, we should or nothing. But I should have been heard at least first.
If I may, my lord,
Just once again, I will not complete that.
1 minute.
First, any order, Lordship, I go down. But I should have been heard first. The writ petition, annexures, everything shows that it was never reached to me. I simply bring Lordship. Let the people remember that complaint. If there is a remand of the repetition, certain issue which can be taken up. I will place all the documents to show that the land where I am residing, so structure below. And electricity connection, electricity connection, forest land, should be done.
How about the third last paragraph of the order, of the impugned order, page 50?
Entire excise note. The respondent was 6.
Yes.
That's what I said. There can be several directions. Simplicity direction, I understand. Authority will take a decision. He will now decide. The second part of direction I will side the Supreme Court. The writ court has to record the entitlement of the petitioner in the order. Then direction will take the decision in light of such entitlement. This order falls within the second category. Every said, my lord, on a fresh construction, forest land, now take a decision.
1 minute.
Simplicity direction, I would have understood my interests protected.
If I may, Your Lordships. Your Lordships, a learned friend of mine is physically present there, would place the
1 minute.
parcel which was received on return.
1 minute, we'll hear you.
My Lords.
These are submissions of the council.
Yes, yes.
The, basically from the fourth para of page 49 or the last paragraph.
My lord,
These are all innocuous orders.
let me say one thing. I have an apprehension in my mind.
What?
My apprehension is, well, it's well founded. Well, let the authority take a decision without getting influenced with any of the observation of the writ court. Because
Nothing has been
my,
my lord.
the order sheet records that I'm an unauthorized construction, it's in forest land. What the authority,
Submission, Your Lordships, it is not recorded. It is only observed that no construction can stand on a forest land, and in this regard, lawful actions may be taken by the rightful executive authorities.
But
This
the-
is the direction, my lord. No prejudice to anyone, and they have given a full opportunity to appear and submit all their documents. That is the direction, my lords.
My lord, the
I don't
honorable
understand why this appeal and how is this adverse.
opponent's right should not be also to be taken to task. As said, the honorable court has specifically passed. You conduct an inquiry, let the authority, you submit before the documents what are there before the authority. If whatever he is saying, I have electricity connection, I have this connection, I have that record, everything will be decided by the authorities. And the authority, until unless who has to be decided, not the anybody has to be decided whether it is a forest land, whether it is a revenue land. As said, the court has directed because complaint was issued to the divisional forest officer, issued a notice. Now, based on notice, this honorable court has said, you proceed with the notice, come to a finding. And both the parties have been directed to appear. So whenever we come to a finding, if it is a forest land, the appropriate procedure, it has to be relegated to the estate officer for eviction. That will be on subsequent issues, my lord. But at present, the order impugned is absolutely correct order because the court was taken care of both the parties. And complaint was lodged. We have issued being a authority, we have issued a notice. And both will be appeared. They will produce what are the documents there. So nothing wrong in this order. The court has not observed anything. The court has simply relegated all the issues to the authorities. You decided. So I pray that the appeal should be dismissed.
My lord, one more submission with regards to the service, my lord. The construction was going on war scale, and that is why by hand service was effected, which was refused by them, and thereafter a postal service was made. My learned friend standing there and physically will submit the written parcel where it is written refused with along with the delivery report, my lords. On 3 consecutive days, it was deliberately refused by the appellant herein. The service was deliberately refused, my lords. My lords may kindly peruse the documents that I'm placing, my lords, physically. Mr. Shihir, I request you to please place.
In all this, whether notice was served, whether you're hurt or not, we're not. What we're noticing in this order is a very innocuous order, protecting the rights of all the parties, allowing you and the others to submit the necessary documents. You will be hurt by the concerned authorities.
no, without being influenced with because some observations is staring in my face. unanswered occupant or false land.
These are recording of the submissions.
So I am saying, Worship, without being influenced with the observation as meant by the writ court, let the authority take a decision. I'll pay a
There
lot.
is no such observation, sir.
That can be done, Lord.
There is no such observation. It is the submission of the writ petitioner.
A single line could have been mentioned against them, then they could have raised the observation. Nothing has been mentioned. They only said revenue authority assisted, complete the proceeding within 3 months, correspondence section. Both is part of the case. So.
Okay, take down. Hurt Mr. So-and-so and counsel for the appellant, as well as Mr. So-and-so for the respondent number.
Respondent number 1, my lord. I am appearing for respondent number 1. Roy George.
On one. And so-and-so for respondents, 3. 3 to 5. You're 6. Okay. Stop. George. Who's appearing for the private respondent?
I am appearing, your lordship. The respondent number 1 named Roy George. I am appearing for.
Okay.
I am the
No,
original writ petitioner, my lord.
respondent number 1. Oh, yeah, okay. Respond number. Okay. Stop. Huh? But this appeal is directed against the order dated 4th November 2025, passed by the single bench, a single judge in WPA oblique 501 oblique 2025, on the ground that the appellant oblique respondent number 6 in the writ petition was not served notice and the learned single judge has made certain observations whereby the entitlement of the respondent number 6, wherein the has made certain observations which is prejudicial for the case of the present for the appellant. Stop. We have perused the order dated 4th November 2025, and on consideration of the same, we are of the view that the said order is purely an innocuous order, and the interest of the respondent number 6 oblique appellant has also been protected by the learned single judge. Stop. In that view of the matter, we see no reason to interfere with the order dated 4/11/2025. Stop. Accordingly, the appeal stands dismissed. Stop. We, however, make it clear that when the authorities considers the case of the appellant oblique respondent number 6 in the writ petitioner, as well as the case of the authorities, as well as the case of the department, any observations made in the said order would not influence the mind of the authorities considering the matter. Stop.
Extremely obliged.
Grateful, my lords. Grateful.
Number 8, detail 34 of 2025.
The lordship by signature is for the fellowship and would pray for a short passing with it.
Who passed the order? Kaushik Chandra is.
No. Honorable Justice Sunil Singh and Honorable Justice Prashanjit Pandey. But not.
Okay, okay. Order was passed by this Somin Sen. And Prashanjit. We can pick up. Okay, after some time.
Payment is starting of 2024.
See, last of week, I see some time.
If paper book is ready, even if it's a transfer brief, my brother was served with the paper book long ago.
Hello.
There's small paper.
Absolutely time.
But since for the appellant on request made by the learned counsel for the respondent. List before the next circuit bench.
For 8.
Respond number 8.
Item number 10. Document 42 of 2024. One for the response. Item 10. Where in item number? You see.
Anybody in VC? Okay. None appears for the petitioner. So and so appears for the respondents. List before the next circuit bench.
Item number 11. Here, DP hall of 2025 with 10 hall of 2025.
So I am for the respondent state. I think name for some time project. That is matter in the next circuit. This is a statutory appeal or appeal conviction. Right for some time.
On request made by the learned counsel for the appellant. List before the next circuit.
Implementing 2 of item number 12, implementing 2 of 2025.
The lordship by finish approval now protection. Lordship, none.
Otherwise, you are ready.
Lordship not.
That's why I was asking you. Don't put your fingers towards the other side. Not today. Not today.
Item number 13, committee 27 of 2025. And for the appellant, matter travel up to Supreme Court. Thereafter, some liberty was granted to that will bulky two numbers of papers which are there. I see some time. So there was a serious case for the respondent. Next. Next.
You want it in the next? Okay. On the, well, for the appellant, next circuit.
Crossover matters. Item number 6, 7046 of 2025.
But this has to be, because I will prepare the informal paper book. My name is appeal, all papers needs to be allowed within the informal paper book. That what to be granted, this can post it to the next time.
How much time you require?
It's one,
Then the counsel for the appellant is permitted to file informal paper book within a period of 1 week. Stop. List before the next circuit bench.
Item number 8. CPN 34 of 925. Item 8.
Not today.